raise the issue about the things that are said in summation, and things can get pretty hot and heavy during summation. So this State versus Williams, which we've called the "Here's Johnny" decision, deals specifically with this matter. Can you talk about this and the old Jack Nicholson movie, The Shining? What happened?
This is a great case on a couple different levels. First of all, it's a bank robbery case, or maybe a bank theft. But defendant goes into the bank and he gives the teller a note, and I'll read it verbatim. It says, please, all the money, hundreds, 50s, 10s, or 20s and 10s, thank you. So he starts out with a please and thank you note. The young teller, and the court mentioned this 3 or 4 times, a young female teller in her early 20s, she gives him about $4,600, something like that. She said that she was very petite, he was tall, so he leans down and looks at her eye to eye, but then hands her, as far as bank robbery notes go, a very polite one. And she gives him the money. She tries to give him a separate stack of money that has a GPS indicator in it. And he said, no, not that one. So he's been around the block. And he runs out of the bank and he's arrested a week or 2 later. So from the outset, and he had no weapon. He didn't say anything to threaten her with any kind of force. He didn't say he had a weapon. He didn't, the old finger in the pocket, pretend he had a weapon, and et cetera, et cetera.
I was hoping I wasn't going to have to do it this way.
What the hell is that?
It's a gun. What do you think it is?
It's your finger.
No, it's not. It's a gun.
Yeah, let me see it.
Get out of here. I'm not going to show you my gun.
So from the outset, it was a very close call between whether this was really a robbery or whether it was a theft. And the assistant prosecutor gets up in summation, and she starts out with a slide, and she's talking to the jury, and she said, well, I think most or all of you have watched the movie The Shining.
Here's Johnny.
And she turns a PowerPoint on, and there's Jack Nicholson, and it's a still taken from the movie after he axes his way through the door, and he's about to kill his family, and he says, as only Jack Nicholson can, here's Johnny. She then went on with the theme of her case, which was that actions speak louder than words. And it's not important what you say, it's what you do before and after. So that's what she was going for. And it might have worked, because this was, it was a tough robbery case. It really was. I thought it was impressive that she did get the robbery out of it. I think what happened is the teller testified that she was frightened. She didn't know what he was going to do, et cetera, et cetera. But the point of the matter was it had to be the defendant's purposeful conduct that put her in fear, not that she overreacted. And I think that's what I would have argued if I were the defense. But, in any event, the court said that to compare what this defendant did to what Jack Nicholson did in The Shining is just way over the top.
Doris, do you think that there might have been a different result in this case if she hadn't shown the PowerPoint, if she had just analogized it and just talked about the movie, talked about the scene in the movie, and asked everybody to visualize it? I think that might have been a different, in other words, the prosecutor was actually too persuasive. What do you think?
Well, I mean, the court does point out that you can't use a picture or PowerPoint display to argue something to the jury that you couldn't argue verbally. So I think if she argued The Shining without the picture, I think she still would have been in trouble. Is that what pushed the jury over the top? I don't think so. I think it was the testimony of the teller and how frightened she was. And another teller testified that, she was shaking and, visibly scared to death. So,
this language I'm going to reference now appears verbatim in all 50 million prosecutorial misconduct cases published by the Appellate Division and the Supreme Court. The duty of a prosecutor is as much to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. While prosecutors are expected to make vigorous and forceful closing arguments to juries, their comments should be reasonably related to the scope of the evidence presented. References to matter extraneous to the evidence may constitute prosecutorial misconduct. When a prosecutor's remarks stray over the line of permissible commentary, courts must weigh the severity of the misconduct and its prejudicial effect on the defendant's right to a fair trial. Courts reverse a conviction only if the prosecutor's misconduct was so egregious as to deprive the defendant of a fair trial. Factors to be considered in making that decision include: one, whether defense counsel made timely and proper objections to the improper remarks. Normally they don't, so you have to use plain error. Two, whether the remarks were withdrawn promptly. And three, whether the court ordered the remarks stricken from the record and instructed the jury to disregard them. Again, these things never happen. They're always done as plain error standard when somebody in the public defender's office starts looking at the record here. The court gives.
Although in this case, the defense counsel did bring it up, and it was the court, the trial court, that said, I'll give a curative instruction, but that's just going to draw attention to it.
Right.
But he didn't ask for a mistrial.
Now, the Supreme Court gives some legal advice to prosecutors around the state, and they say the following: to avoid objection or possible error, the court encourages counsel to disclose to each other and the court any visual aids intended to be used during closing argument, but does not require that practice. Nevertheless, the court reminds prosecutors that they must ensure their strategy and commentary fall within the boundaries of permissible forceful advocacy. Prosecutors must walk a fine line when making comparisons, whether implicit or explicit, between a defendant and an individual whom the jury associates with violence or guilt. The use of sensational and provocative image in the service of such comparison, even when purportedly metaphorical, heightens the risk of an improper prejudicial effect on the jury. Such a risk is borne out here. Visual aids such as PowerPoint presentations must adhere to the same standards as counsel's spoken words. Slides may not be used to put forward impermissible evidence or make improper arguments before the jury. A PowerPoint may not be used to make an argument visually that could not be made orally. PowerPoint here fell short of that standard. Let me just take a second and ask Joe. Joe, what do you think about this mess?
Okay, what I think about, when I read the factual pattern here, I could not think of any other movie other than Take the Money and Run, the Woody Allen movie. In the Woody Allen movie, Woody Allen goes up to a teller. He's got no weapons on him. He's a schlubby guy, and he's dressing in this schlubby way. And he passes a note to the teller and says, "Give me all the money in the drawer. I have a gun." So the teller takes it out and she reads it. She says, "Give me all the money in the drawer. I have a gun." "What's a gun?" No, that's gun. No, it's clearly a B. No, it's an N. No, it's an N. No, it looks like a B. And he says, "No." She says, "Wait a minute, Doris, you come over here. What do you think?" "Well, it could be an N. I don't think so." "Larry, come over here." And then he said, "No, it's." So they finally, 8 people are there arguing over whether it's an N or a B, and they're having this discussion. And no one's paying attention to Woody Allen. He just shrugs his shoulder and walks out of the bank dejected. That is what this note reminded me of perfectly.
Joe, I thought, knowing you as I do, I thought you would have said, "Boy, I wish I'd thought about this. This is a great idea."
Well, no, the guy that I like was the guy in Hudson County who got a bunch of deposit tickets, when he opened up a new checking account. And then one day came up with a brilliant idea. He went over to the table where you have all the forms, your deposit tickets. He took out the blank ones, put in his deposit tickets. And everyone that was putting in deposits that day, they didn't look down to see that his account number was on his name. And they were making all their deposits into his account. When it got to be $100,000, he took out all the money and disappeared. Now, here's the crazy thing. Because he's from Jersey City, where I'm from, and, $10 is a lot of money. When they found him a year later out on the West Coast, he still had 94,000 of the 100,000. He only spent $6,000 in his year crossing the country because this was a fortune to him and he had to save the money. So to me, that's what this reminds me of.
One more reason to move Hudson County out of New Jersey. So can you talk about the expungement of TO, which does not stand for Terrell Owens? This is a kind of a unique legal issue that I'd never encountered before, dealing with the interplay between expungements and pardons. Can you talk about it a little bit?